Okay, there's a really interesting case out from the United States Supreme Court this week about geofencing, and I want to talk about it because it has some implications for actually stuff beyond geofencing, and in particular, this whole world of mass surveillance that I've been kind of interested in recently, and that I think some folks are interested in who watch this channel. Chatry is about the practice of what's called geofencing. And geofencing is used by law enforcement a bunch now. In the opinion in Chatry, it talks about the fact that in 2018, Google was receiving 11,000 geofence warrants every year. So it's a very common law enforcement tool. And what geofencing is essentially is sweeping in all the information about cell phones that access a particular tower or particular transmitting point. And that can be useful for identifying potential suspects in a crime, which was what was going on in Chatry. And law enforcement can take that initial broad pool and then narrow it down and eventually hopefully get to particular individuals. But the point is that doing that initial search of everybody who's in the vicinity of some particular tower potentially implicates individuals' right to be free from unreasonable searches and seizures. And the Fourth Circuit had said in Chatry that that was not a search, and so it didn't implicate the Fourth Amendment. The United States Supreme Court reverses. They say, no, it is a search. It is a search, and it kind of follows along a line of cases that has come out from the U.S. Supreme Court that has to do with cell phones in particular and the centrality of cell phones and cell phone data to contemporary life. There was a case called Riley back in 2014 that requires law enforcement to get a warrant to search a cell phone. And there was a case more recently called Carpenter. And Carpenter had to do with location, cell phone location information. And this geofencing theory that's going on in Chatry is really like hand in hand with the whole question of cell phone location information. And indeed, that's basically the analysis of the majority is like, hey, this is quite a bit like what we already said in Carpenter that does implicate the Fourth Amendment. In fact, it's even more specific because in a geofence situation, we're focusing very, very narrowly on a particular physical location, and that implicates reasonable expectations of privacy. And against that theory, the dissent, Justice Alito in particular, and the people who join in the dissent, emphasize that there's this thing called the third party doctrine, where if you hand over your data voluntarily to something like a bank or a phone company, and the government later contacts the phone company, say, that's not necessarily a search of your effects. They're just contacting the phone company. And here again, there's this sort of notion that your data is being voluntarily, you are voluntarily agreeing when you click that little terms of use box on the phone or whatever, you're voluntarily agreeing to turn over your data to Google, and it's being transmitted to the towers. And so perhaps the argument goes, you shouldn't complain when the government later accesses that data. But as the Supreme Court has emphasized in Riley and Carpenter and now in Chatry, cell phones are kind of a different category of thing because we use them so much. They're just ubiquitous in daily life, and they pinpoint our locations at almost all times. And so if we say that we just sort of give up any reasonable expectation of privacy merely because we're carrying a cell phone, then game over. Like we're being tracked all the time everywhere, and that's a serious issue. So Chatry comes down and says, no, that does implicate the Fourth Amendment, and whether the warrant here was appropriately tailored or not is something that's going to have to be sorted out on a remand. But the point that I wanted to really emphasize in this case is a line from the majority opinion that specifically pushes back against the third-party doctrine and says, nor does it matter that the materials obtained were handed over by a third-party tech company. A third-party tech company. Okay, and what that calls to mind for me is Flock, a third-party tech company, Flock, or other third-party tech companies that are now in the business of surveilling everybody constantly and selling that data to the government for use in law enforcement. Is that a search? Is that a search? And I'm perhaps a dividing line here is, well, that doesn't involve your cell phone. The fact that Flock can monitor your license plate at this overpass and that intersection and constantly keep track of your data does not involve your cell phone. So perhaps that's a dividing line that puts Flock in the clear and makes it that their activities are not a search. But on the other hand, if this kind of digital granularity aspect of the whole thing that the majority emphasizes in Chattree matters, then the extraordinary degree of granularity that these types of data sets provide, data sets from Flock and other companies like them, the extraordinary granularity of those data sets ought to push what they do in the direction of being a search when the government accesses them. So I think that's a very interesting question, and I think it is going to have to get litigated in the future. In Carpenter, Justice Alito flagged the notion that if we're moving away from sort of third-party theory when it comes to high-tech data stuff, that he said, we're opening up a Pandora's box where people are going to have all kinds of claims around searches that are not quite like what we normally think of as law enforcement searches. And in his dissent here in Chattree, he says, I was right. This case is going to send seismic waves through our Fourth Amendment doctrine, as he puts it. And whether that's true or not, I don't know, because it might be the case that this really will be limited just to phony type, and I don't mean phony, I mean cell phony type situations. I'm not sure. But the point is that where the Supreme Court is emphasizing that collecting a lot of very specific data about people's locations starts to get us into the umbrella of the Fourth Amendment concerns, then surely a system that is surveilling everybody all the time has at least the potential to step onto that Fourth Amendment terrain. So I think that's going to be really interesting to watch as this goes forward. Chattree's an interesting opinion just for what it is, but it's going to be super interesting for how it plays out as it applies to these other technologies that we're all grappling with right now. And the interesting thing about them, of course, is that it's just the nature of capitalism, for better or for worse. They roll the products out first, and then they figure out later if they were legal. So these systems are everywhere, all over across America, and perhaps they already violate the Fourth Amendment. We won't know until a few years from now, but that's the fun of law.